so that our friends and colleagues who didn't have a chance to join us today can see it later on our YouTube channel. So while I think we'll give it 1 or 2 minutes for others to join us. Okay, so I will not take much time from our speaker today. Let me introduce him. This is Mr. Ben Wells. He is a solicitor advocate and a partner at Candey law firm. And our speaker today will tell us more about the area of his legal practice and tell us more about matrimonial claims in English common law. Mr. Wells, the floor is yours.
Danaya, thank you very much. Thank you for the warm welcome and the fantastic organisation for this talk today. It's really great to be able to be here and to speak with all of you, especially the fact that I'm in London at the moment, but to be able to speak to people all over the world, including in Kazakhstan, is absolutely fantastic. So I've already been roughly introduced, but that's all correct. My name is Ben Wells. I'm a partner at Candey. We're a litigation boutique law firm in London, based in Lincoln's Inn. In addition, I'm a solicitor advocate, and I'm in quite a few groups. So I'm on the committee for the British Kazakh Law Association. Also, I head up the Eurasian CIS Legal Professionals Forum with 3,000 Russian-speaking solicitors, lawyers all over the world. We host a fair few events. And in fact, through the BKLA and the Bar Council, with the support, thankfully, of the AIFC and also the British Embassy in Astana, we hosted 2 events in Kazakhstan last month, which were called English Law Days. So we spoke about lots of the different things that we're going to speak about today. We had a wide range of sessions, and we were lucky enough to have 2 of those English Law Days, so one in Almaty and one in Astana. And it was absolutely amazing to have the opportunity to meet with many of you at those events over the course of the week. We've had really good attendance. I think we had about 100 people pass through each of the conferences. So that was a real joy to be able to attend and speak with so many people. And I suppose an extension of those particular events and conferences that I'm here with you today to talk more about English law. This is supposed to be an interactive session. I will go through a few bits about matrimonial claims, but very happy to speak about other subjects as well, including how to become a solicitor or a barrister in the United Kingdom, if that might be of interest to you, or any other issues that you might think are of interest that we would be able to speak about. Very happy to do so. I'm not sure, Danaya, do we have a chat function, or how do we do the questions? Is it easy?
Yep, we do. Everyone can state their questions in the chat box or just turn on their microphones, maybe during or after.
Okay, perfect. I'm just opening the chat as well. And I'm putting the link to the LinkedIn group for the networking group that I run, in case any of you would like to join up for that. So in terms of today's presentation, we're really focusing on matrimonial claims. I've worked with quite a few individuals in these type of claims. They are difficult claims because there's always a lot at stake and emotions are very high. So it's quite delicate in order to deal with these in the correct way, and you have to be very mindful of your client, their interest, their understanding, and also very often there are children involved. So it's it's a very delicate area of law. At the same time, it can be very rewarding for your clients and for you as an advocate to be able to represent them in the best possible way, especially as there are some interesting features of English law which do allow people to get good awards in terms of the assets that have been held between couples. And I represent both ex-wives and ex-husbands in their claims against assets and other things within the estates that they hold. And there's specifically a power in the English courts to grant financial relief, and that's under the Matrimonial and Family Proceedings Act 1984. So after a marriage has been dissolved or annulled in a foreign country, so that could be in any of the states of the former Soviet Union or CIS or whichever label you would like to assign to it, under that law, a party can establish maintenance for their children, they can obtain payments, or they can divide property. So to put this into context, I'm going to cover the significant case from 2010, which was heard in the Supreme Court in the United Kingdom, because this case really clarified the scope of the power of the English courts. This case is called Agbaje versus Agbaje, and I hope I'm saying that right. The couple spent most of their married life in Nigeria and had divorced there, but they had a house in England, so there's a connection with England, and the wife was living there when the divorce was granted. So the Nigerian court made an award, so the foreign court, so it's all falling into the litigation, to the ex-wife, and it's a life interest in the property that the couple owned in Nigeria, as well as a lump sum of money, which was the equivalent of £21,000. The ex-wife then applied for financial relief in England under Part 3 of the Matrimonial and Family Proceedings Act. And the English High Court ordered that she should receive a lump sum, which would be equal to 65% of the proceeds of the sale of the jointly owned house in England. The award actually represented 39 or very close to 40% of the couple's total assets. And this decision was overturned by the Court of Appeal, but ultimately then upheld by the Supreme Court, which held that the whole purpose of Part 3 is to alleviate adverse consequences of no or an inadequate financial provision being made by a foreign court in a situation where the parties have substantial connections with England. So following this landmark decision, counsel for the ex-husband said that whereas the Court of Appeal had taken a very restrictive approach to Part 3, the Supreme Court has opened the door to potentially large numbers of claims. It also seems likely, he said, that awards under Part 3 will be bigger than in the past. Indeed, in cases where the parties have close connection to England, awards will be at the same level as if the divorce had taken place in England. So the current position of the English law is that family courts are likely to make generous awards of financial relief to parties who apply successfully under Part 3 of the 1984 Act. I'll refer to this as Part 3 relief. So in terms of this short presentation, firstly, I'm going to tell you about how to establish jurisdiction of the English courts to grant this Part 3 relief. Secondly, I'll explain how to make an application for Part 3 relief. And thirdly, I will look at which factors the court considers when deciding relief, whether it will be granted and which kind of relief to grant. After that, I'll talk about a more recent case than this one, where an absolutely humongous award was made. So we can see this all happening and how it is progressing within the English courts. So either party to the marriage may apply in England for this relief if they are divorced or if their marriage has been annulled using a due process of law. That means that the divorce is then entitled to be recognised under English law. The applicant must be able to show that on the effective date of the divorce or on the date of the application for a Part 3 order, and there are 3 strands to this requirement, that either party was domiciled in England and Wales, either party was habitually resident for 1 year in England and Wales, or one or both of the parties had, at the date of the Part 3 application, an interest in a house in England and Wales, which was the matrimonial home at some point during their marriage. And this one does come up a lot. So for example, where you have a couple from Kazakhstan and they own a house for example, in London, this would apply to them if they were then to get divorced in Kazakhstan. Either the wife or the husband could come to England to have some aspects of the divorce award decided within our jurisdiction. Some important points to consider before you bring your claims. If a party has remarried, that party cannot make an application under Part 3. Where jurisdiction is based on an interest in property in England, so the instance we were just talking about, the power of the court is actually limited to the interest in that home or the value of the interest. So if the house is worth, just using round numbers, £1 million, the award could not be 10 million. The award would have to be limited to the 1 million figure, which is the value of the property. For a divorce to be recognised in the English court, it must be obtained by judicial or other proceedings in any country outside the United Kingdom. It has to be effective in that country as well. So either applicant was ordinarily resident in that country or was a citizen of that country where that award was made. And to make the application, you need to prepare a statement and submit an affidavit detailing why the applicant believes it's appropriate for the English court to make an order. The statement would usually address the following points. So the details of the proceedings that annulled or dissolved the original marriage, the names of the parties, their ages, dates of birth, and the date of the marriage, the parties' occupation and home addresses, information regarding their children, if any, whether either of them has remarried, and the income of the parties, their wealth, and income of any children under the age of 18. They also have to set out, lastly, the facts of the case and the grounds upon which the court is said to have jurisdiction under Part 3 to hear the application. So the application actually consists of two distinct steps. First, the applicant has to apply to the court for permission to apply for an order, and this is called the application for permission, and this must be filed without notice to the other party. Engaging in advance whether this is likely to be appropriate, the court gives consideration at the permission stage to some of the factors, which I'm going to cover in a second. If permission is granted, the court will consider these factors in more detail at the second stage, namely the hearing of the substantive application for relief. So it has to consider the parties' connection, in particular the connection that the parties to the marriage have with England and Wales, the connection they have with the country where the marriage was dissolved or annulled, and the connection with any other country outside England and Wales. This is all looking at the correct jurisdiction for claims to be considered. That's why you're looking at connections with other countries as well. You have to set out the financial relief. So this includes any financial benefit that the applicant or one of their children has received or is likely to receive because of the divorce. So you really want that to capture any and all payments that have been given, so that the court in England knows what's already been paid and they will better be able to judge on what further payment, if any, should be made. Where orders have been given in foreign courts, the financial relief given should be set out and as to whether that has been complied with or not. In addition to any right the applicant has to apply for further financial relief, and the availability in England and Wales of any property for which an order under Part 3 could be made. So if any property is owned, that should be specifically set out. Enforceability, that is the extent to which an order made under Part 3 is likely to be enforceable. Otherwise, what's the point in getting the order if there's absolutely no chance of it being enforceable? It does seem slightly like a waste of time. And time elapsed since the decree. So that's the length of time that has elapsed since the date of the divorce, annulment, or legal separation. In order to get permission, you have to show that you've got a substantial ground, and that's detailed in this case that we were just talking about the Supreme Court on. And you must also be able to demonstrate that you have more than just an arguably good cause. The applicant must provide copies of their application, statement of support, and order to the respondent. Second, there's the substantive application. So once permission is granted, you can go on and do your substantive application, and both parties prepare a financial statement in, it's called Form E, is where this financial statement is shown, and the matter can then be listed for hearing. It's this stage which parties usually get quite uncomfortable, because whoever's being claimed against generally doesn't like to have to put down all of their assets into the form in order to show their former spouse. So there are a couple of factors which decide as to whether permission is going to be granted. Generally, they will look at the welfare of any children. Where possible, they will also look at the result of the provision will account for the reasonable needs of each party. But the court has a very broad discretion in doing this. In the case of Z versus Z, 2016, if there is some delay before you bring your claim, that's not absolutely fatal. So you can wait some period of time. Obviously, it's always better to make the claim as soon as possible. But in this particular case, the judge considered it would be appropriate to make a financial remedy following a Russian divorce under Part 3, despite the wife's delay of 5 years in bringing proceedings and the existence of a Russian financial order compromising all claims worldwide. Roberts J. accepted that the wife had not let matters drift, but was actively engaged in seeking advice. The order was based on the wife's needs, although it was restricted to reflect that delay in the claim being brought. So that particular order was overturned on appeal. However, the Court of Appeal clarified that a delay does not prevent the court making an order for Part 3 relief. In another case of Patyanin and Patyanin of 2019, the judge denied the ex-wife's motion because she did not have a strong enough connection to England. So in this one, lawyers acting on behalf of the ex-husband argued that the ex-wife had only moved to England in 2014, specifically to begin a lawsuit to try and obtain a large sum of monies from her husband's alleged estate of $20 billion or so. Another slightly more recent case in Akhmedov v. Akhmedov, 2021, the English court awarded the ex-wife financial relief of £453 million, which was 41.5% of the total family estate. This decision was hotly contested by Mr. Akhmedov in Russia and was the subject of some quite furious disputes. In the end, the ex-wife got assistance from a third-party funder and was pursuing assets around the world. She managed to get a very expensive yacht detained in the UAE for some time, and there were lots of news reports on this at the time, showing photos of the yacht and talking about its value. I think that in the UAE, in the end, the ex-husband was able to get the yacht released. And in fact, despite efforts in many different jurisdictions, the ex-wife was having difficulty in locking down assets to enforce the very substantial decision in her favor. And I believe that that case did settle in the end, although I'm not sure the sum for which it settled. But clearly having a decision in your favor of £453 million is extremely substantial. In fact, there was another case after that, which involved Sheikh Mohammed and Princess Khaya. And in that case, she was awarded an even larger sum. So it was in the amount of over £500 million. And that was simply because the ex-husband's estate was so substantial that she was able to get an award in that amount. And that was a very interesting case with a really detailed judgment. So if you do have time, I would really recommend reading that judgment because it's absolutely fantastic. And the way that it covers the law, it explains everything very diligently and about all of the applications which were made by either side, because there really was such depth and breadth of arguments being raised within that particular case and lots of interesting things going on in the background. So highly recommend to have a look at that if you have the time. Danaya, should we go to any questions now if people have them?
Yep, there is actually one question.
Okay.
Is there an official statistics of the family division, the High Court, on matrimonial cases, on a number of cases, cases being dismissed, and so on?
Yes,
there
probably are, yes. I don't have the stat to hand, but certainly it can be quite difficult to get past the permission stage on these Part 3 claims. So I would expect that it could be fairly high. Previously, the United Kingdom was known as the divorce capital of the world. So due to these kind of judgments, where, for example, Akhmedova was awarded £453 million, or Princess Haya was awarded even more, in excess of £500 million. If there are very wealthy people, they may look at that and think, instead of resolving my divorce dispute in Kazakhstan, I would really like to do it in England, because I believe that the English courts will award me a much greater amount of money. But the difficulty is, if there's a property within the jurisdiction, then it's much easier to pass the first limb, the first test, in order to be able to be heard. However, in other instances, where an ex-husband or ex-wife moves to England after the divorce has happened, and the court sees that that has been done specifically in order to try and get jurisdiction, then they can be very hesitant in order to grant it. So potentially there could be lots of cases where the first limb or first test is not passed and people are not able to progress their matrimonial proceedings in the United Kingdom. I can see another question coming up in the chat. Are the UK courts more likely to use ADR for matrimonial cases? And that's a very good question. In terms of whether they're more likely to use it, I'm not so sure, but the English court in general are very, very happy to promote ADR, including mediation and other forms of alternative dispute resolution. And so in most cases, regardless of whether it's a matrimonial claim or normal litigation, the court will ask the parties to go off and consider whether they can settle their claims, as opposed to going through the full rigmarole of litigation, which is time expensive and also costly in terms of the money that you have to invest into those proceedings. So it's the usual case where they will turn away the parties and say to them, right, you need to go and have a proper think about this and see if you can settle. And in addition, if one of the parties tried to suggest mediation or some other form of ADR, and the other party refuses, that's generally looked upon very dimly by the courts. So they would say that was unreasonable that you did that, and they may look at that when they come to address costs in the case when the proceedings have concluded.
Hello.
Hello.
Yes, I would just like to ask a question. You just said now the courts will look if one of the parties will refuse to go for the ADR, and the courts may look at it.
Yes.
Do you mean like the courts may take into account the factor that one of the parties refused and use it as a as kind of to make any kind of decisions or any kind of conclusions as a factor that the party refused? Well, does it drive to any kind of conclusions for the courts?
Yes, definitely. So the way that the courts can punish a party which they believe has not come to the proceedings with clean hands, i.e. they have done something detrimental to the proceedings on purpose, is by looking at the question of cost. So when you come to the end of the proceedings, they can say, we believe party B has been, you know, disrespectful to the court or has elongated the process unnecessarily, and therefore we're going to award party A higher costs or potentially costs on the indemnity basis. So that's when, in an extreme situation, yes, and they'll give a higher percentage on those costs when awarding them.
Right. Thank you. Thank you very much.
You're welcome.
There is another question.
Yeah.
Please share your experience on legal fees recovery on matrimonial cases. Are there any statutory limits on legal fees recovery? Not sure.
Statutory limits. Yeah. So when you look at costs and they are awarded by the courts, they do have set rates for solicitors and barristers within different areas. So, for example, my law firm is located in London, in the city of London. And so there's a particular hourly rate for the different grades of employees. You look at the different grades of employees. For example, for a partner, there'll be a set rate. I'm not sure exactly the amounts, but there will be different rates for senior associates and all the way down the waterfall of different positions of people who work in a law firm. And they will assess whether they think that the fees that your firm or the other firm on the other side has charged, whether those fees are reasonable. And they will come to a conclusion. But previously, you would not really expect to get your full amount of fees back, especially where very high levels of fees have been incurred. However, with budgeting now, you can really budget ahead in terms of the cost that you're going to incur, and you can have those approved by the court in advance. And if you've done that very carefully, and you do come in at the rates that you have expected, and it's been approved by the court, there is the chance that you can get 100% of your fees back now in current practice. And again, that's not specific to matrimonial disputes, but any disputes within the court system in England.
Oh, we have another one. Are there any upcoming British Kazakhstan legal related meetings in Almaty or London?
Yes, so upcoming meetings. We've certainly been talking about putting on a fair few meetings in the coming months. We had a meeting of the British Kazakh Law Association, and also with the British Kazakh Society, we're definitely trying to host an evening talking about how to bring more business to Kazakhstan. We don't have a set date for that one yet, but I will make sure if you're able to join the LinkedIn group for the group that I shared in the chat function, we will be releasing all of the details there. And in addition, hot off the heels of our English Law Days in Kazakhstan, we are hoping to do an English Law Week in the spring of next year. We're waiting to agree the dates for that, but we're very much hopeful that that would cover Almaty, Astana, and potentially Tashkent as well, to get a delegation of speakers from Kazakhstan, Uzbekistan, and also from the United Kingdom to speak on relevant issues in 2023.
Okay, thank you. So anyone wants to maybe turn on their microphones and state a question?
I'll just have a question as well. Again, sorry, I've missed the first part of today's presentation, so I may have missed some information. So my question is, do parties, while entering into a marriage, well, I don't know how to put it right. Well, I know in France they have several types of contracts before entering into a marriage. So depending on what kind of contract they enter, it will well stipulate the terms for a divorce. So when they divorce, if they choose a contract A, let's say, upon the divorce, the parties will be eligible for some kind of well, I don't know, share of the wealth, depending on the contract you choose. Is there anything similar in UK or Is there just one simple contract?
Sure, yes. So I think it's called a prenuptial agreement, or prenup is the short that people usually, short form of the expression that people usually use. And these do work in England. However, there are several caveats. So I do not think that they are as solid as they are in other jurisdictions where I've heard that these agreements work very well. I know that with the jurisdictions I've been dealing with recently abroad, they really do work, where it's more nuanced in England as to the way in which they work. Unfortunately, I am a dispute solicitor only, so I only deal with the elements after the kind of prenup or transactional parts will be done. So I can't advise you any better than that, I'm afraid.
Right. Sorry, can you spell the agreement, the pre?
Yeah, sure. So if you type in PRE and then with a space NUP, it should come up straight away.
NUP prenup. All right.
Yeah. And it stands for prenuptials.
Prenuptials. Right. Thank you. Thank you.
You're welcome.
Hello. Yeah, I actually have a question about your own experience. Can you tell us about more about, for example, the most challenging matrimonial case you've ever had? Maybe it concerns jurisdiction or other interesting questions.
Yes, certainly. So I've worked on a very interesting case for the former wife of an oligarch, and I won't name any names, but that case was with regard to part of the ex-husband's estate, and it was in the amount of many billions of dollars, and there were claims against that estate, including against the value of that individual's claims against other parties. So it not only looked at his real assets, but also assets that he might have in the future. So that was quite an interesting one in terms of assessing the chances of his litigation elsewhere as to how much money he might earn and stating the ex-wife's claim to those assets. I can't go into a lot more detail, I'm afraid, but it was a really interesting case to work on. And in fact, that was my first matrimonial dispute that I worked on that really led me to working on others. So it was a really good experience.
Oh, thank you. I also have another question about the gifts. How are they divided? Are they considered, like, if one spouse receives a gift, is it considered a marital property or not during the divorce, I mean?
Yeah, so it depends on sometimes on the law of the jurisdiction where the people got married. So certainly there's going to be specific legislation that addresses gifts usually.
Yeah, in the UK, for example.
Okay, it's just these claims, the ones that I'm talking about, only deal with divorces in foreign jurisdictions. So that's the way that we would usually look at it. And lots of the time, especially in England, the position is that it's a 50-50 split, unless other agreements have been made with regards to perhaps the way that property, houses or flats are held, because you can agree between the parties that it's either 50-50 or they own a particular share, and you can set out the percentage share of those properties as they've been held. Usually gifts would fall to one individual, so if they were gifted, they would be retained by that individual. And you'd really hope as well that the person that gave the gift would be willing to admit that was a gift and for it to remain with the other person. However, there are situations where gifts are of extremely high value, and then the person who presented the gift reneges on that gift giving, which isn't really in the spirit of Christmas or New Year, but certainly these things do happen.
Thank you.
If I may, I also have a question.
Of course.
Do you have an experience of being not a representative of one party, but a mediator to help both parties to find the exit out of this case, out of this situation?
Yeah, sure. I've worked as counsel predominantly on these kinds of matters. However, I've previously worked as a mediator on other matters. Mediation does have a very high percentage rate of success, so it can be a really useful thing to do. Now, mediation in matrimonial claims, I'm not going to say it's more difficult than mediation in other types of claims, because that would be rude to mediators who work on other claims. But clearly, there's a lot more emotion involved in matrimonial claims than there are in disputes between companies or directors of companies. Even where a company is the director's baby and he or she is the sole shareholder, I still think that that's far more complicated in terms of marital disputes, especially where children are involved. So it's probably a difficult task to do, but certainly with the success rate of mediation overall, it's certainly something that's worth trying, because if there's any way to avoid the courts, then that's fantastic, not only for the parties, but also for their children. If the mother and father can agree on what they're going to do going forward, that's really important. Personally, I sit as an arbitrator as well for Russian language disputes with an English law element. And so it's great to be able to help parties to decide those disputes. And I'm registered with the AIFC, of course, and also with a couple of institutions throughout the FFU, so RSPP and Russian Arbitration Center, those kind of centers. So it's always interesting to see from the other side of the coin, as an arbitrator or a mediator, what the parties are looking for and what you expect from counsel as well, in terms of their submissions and how best to resolve the dispute. But certainly this is an area which is ripe for mediation, and I know that it's tried on multiple occasions, but potentially it could be slightly more difficult than more commercial disputes where there's less emotion involved and at stake between the parties.
And what is the statistics? Do people tend to choose mediation over the courts, or is it like a case by case situation?
Yeah, so it depends on the field in which the dispute is. In some areas, for example, property disputes, there's a special centre in London where I worked, and you go straight to mediation first. And it's only if the mediation doesn't work that you would go to court. However, I think in the majority of dispute fields, you would usually go to court and run the mediation process at the same time. Now, whether that's correct or incorrect is hard to say, but potentially if the mediation process is more towards the beginning of the proceedings, then you have the potential cost savings of deciding that dispute and not having to go through courts. So it can be very useful.
Okay, thank you.
I know the AIFC is doing lots of mediation at the moment, so I don't know what your experience is.
Sorry?
I believe the AIFC is doing lots of mediation at the moment, so I'm not sure if you have any statistics or experience you'd like to share about those mediations.
Yeah, maybe our colleagues from the court to help
Courts could do so.
statistics.
Okay.
Yeah, because the arbitration is the arbitration cases in the AIFC are there are more of them than the court cases.
Yeah, understood.
Okay, dear colleagues, any more questions?
Yeah, I think I have one more question left related to your question, probably. It's about the cultural differences. As you mentioned, you work for both jurisdictions, right? For the Russian language and for the, I would say, English language. So have you observed any kind of similarities or differences in the way of, people divorce, or in the way of their subjects of their matrimonial cases? I don't know.
Yes, sure. Very good question. There are different cultures in every place that you go to, wherever you travel. There are different languages and different accents, even within England itself. If you travel to the town next to you, you might find that someone has a completely different accent from yourself. So there are clearly massive differences in culture and language between all of the respective countries that we've been talking about today. However, I think there are lots of commonalities as well, because when you do get in a very unfortunate situation, such as a matrimonial dispute, I think that some of the tactics used by the parties can be seen transnationally. So regardless of where you are, you will find that husbands and wives are arguing and putting forward similar arguments with regard to the asset. Something you raised, Idana, about the fact that something was a gift, i.e. that the car was presented to me as a present and it should remain with me, or with regard to custody over the children, which is another element which plays in the background of the claims for particular assets. You will hear similar arguments wherever you go. So nothing is really reinvented, and you will meet the same arguments everywhere.
Okay, another question. Is your law firm hiring lawyers from the CIS region? If so, please specify the process.
Yes, sure. I mean, this is an interesting one. We are expanding at the moment. So we've got 50 fee earners overall at Candey in London. We've just opened an office in New York and one in Washington. So we are expanding, and we are taking on additional or looking for additional employees at the moment. In terms of the process, it really depends where the potential candidate is. If at all possible, we like to meet in person at our office after submitting a CV and to have a chat with the person and see what they're like. At the same time, we do interviews over video conferencing as well, because we understand that people are in all different locations. We're quite lucky that we're signed up to the visa support system. So we have some trainee solicitors from all different regions of the world, as well as solicitors who are supported on that scheme. So it's really good that we can offer that to people from Kazakhstan as well, should they be applying and need that kind of support. But the process isn't particularly complicated. The things that we do look for in our employees are absolutely stellar results at university. So if at all possible, we like them to be from a really reputable university with exceptional grades. So we would look for people with a first in their degree, or whichever grade that would be in the jurisdiction in which they come from. And in terms of their experience as well, it's really important that people have a good breadth of experience. So you don't have to come straight from university. You can have experience in other fields and sectors as well, be able to build up your resume and to have some really good experience to draw on when you come into the role. We give a tremendous amount of responsibility to junior employees. So we will have trainee solicitors and pupil barristers who may at another firm, especially for on the solicitor side, may be assigned to kind of bundling tasks or something like that. At Candey, you would be drafting substantial documents yourself, first draft, and submitting that to the team. We're a partner-led service, so we have a high percentage of partners working on matters, because we want to make sure that everything is done really correctly and to the T. So in terms of the structure, we look to pair up all of the team together and ensure we're getting the absolute best work product for the client. Language skills are really fantastically important. It's been very helpful to me that I speak Russian in order to be able to develop my practice. And certainly if candidates have other languages in their skill bank, that's fantastic and really helpful. So I hope that has covered the answer to your question and explained some of the things that we look for in our candidates. And yes, we are looking for people at the moment.
Yeah, by the way, Mr. Wells is a very good Russian speaker. That was a surprise for me when I met him in Astana during English Law Days. We're speaking English, and suddenly just Mr. Wells saying something in Russian, like a native speaker. That was good.
Thank you very much. It's very kind of you to say.
Okay, more questions? Okay, Mr. Wells,
Yes.
so I will be sharing your LinkedIn so that
Great, thank you.
Our participants may either contact you or just
Definitely, yes.
share news with you. Thank you for your time today. Thank you all participants for stating your questions. They were quite interesting, and we hope to see you on our next English Speaking Club sessions on our legal and business topics. Thank you, Mr. Wells, and have a
you.
happy new year, everyone.
Yes.
Thank you. Thank you.
Thanks very much, everyone.